So let's switch gears into temporary work permits. In the US, we often refer to these as non-immigrant visa statuses. Most common types of temporary work permits in the US would be the H-1B, the L-1 intercompany transfer, E-1s and E-2 for the treaty trader investors. Mark, can you just give us some overview in terms of how temporary work permits and non-immigrant status have been impacted by the coronavirus, and what can and can you not do at this point in time?
Well, it's important, as you pointed out, to note that the USCIS and the Department of Labor here in the United States are continuing to process applications. So with USCIS, there are a lot of field office closures right now, and basically all of their in-person services have been suspended at all their offices in the United States. But service centers continue to process cases. So if you're filing for a new application in a temporary work visa category, a change of status, an extension of status, even if you're applying for other applications in permanent statuses, which I know we'll talk about later, the service centers and the Department of Labor are continuing to process those cases. So for employers at status quo, you need to continue to file those cases as normal. Now, there are a couple differences in the way those cases are being processed. One, premium processing, which is a program where an employer can pay an additional government filing fee to get expedited 15-day processing. Premium processing has been temporarily suspended, so that is no longer available. And in some cases, that can create an issue for individuals who needed to have a change of status or an extension of status approved by a date certain. Right now, it's a little bit more tricky to do without having premium processing available. That said, you can, when you file a case, you can request what's called a discretionary expedite. You can ask the U.S. Immigration Service to exercise their discretion to review the factors of your case and potentially expedite the case without premium processing. And usually they're focusing on humanitarian issues or severe economic damage if you're not able to have a person's application approved by a certain time. And I would say that one of our practice areas at Ellis Porter is in the healthcare field, and we've had a lot of success filing expedited applications for individuals working in healthcare occupations, so they understand the urgency of getting those applications approved on a timely basis. But the other thing that's been interesting to see is even in cases where we have not requested an expedite, we've had H-1B extension applications filed and approved in 3 to 4 weeks without premium processing, whereas before the pandemic, a non-premium H-1B extension case might take 6 months or more. These cases are now getting approved in some cases in 3 to 4 weeks. So I think even though premium processing is not available, and even though you may think your case doesn't qualify for an expedite, it may actually end up being expedited anyways, just because I think USCIS may temporarily have a lower volume of filings right now, and some of the cases are actually going through a little bit more quickly than normal.
That's great. In terms of, I know certain non-immigrant statuses like the H-1B and the E-3, you are required to file a labor condition application with the Department of Labor to ensure that the prevailing wage is checked in the area of intended employment. So the Department of Labor has introduced a 30-day grace period for allowing you to post those LCAs. Typically what would happen if you have a material change that would require you to file a new LCA or post an LCA in a new worksite location, you'd have to do that prior to moving or at the same time. You now have that 30-day grace period allowing you to post within 30 days of that move as well, which is definitely beneficial. And then I think another good change would be the wet ink signatures, and you've probably seen that a lot more being in the US on the ground with filing a lot more with USCIS, but you can now use digitally reproduced signatures as opposed to having the original signatures, which obviously has been beneficial as people are working remotely.
Yeah, we're hoping that's maybe that's a change that sticks around permanently, because logistically, with the way the everything works now, as far as working with employers. A lot of employers have moved to electronic signatures. The fact that we still have to get wet ink signatures on an immigration filing really makes things very inefficient. And so, out of necessity, they dropped that requirement, and they're allowing us to file applications with just copies of signatures, because you have a lot of HR professionals who aren't even working in their offices and they're working from home, and that's a necessity. But we would love to see that continue on, because it definitely makes things more efficient for HR professionals, for the foreign nationals, for the law firms that represent them, and I think ultimately it would be more efficient for the USCIS as well. But that may be wishful thinking. We'll see if that sticks.
Right. And Rahul, I mean, in the UK, you've come off the back of Brexit, which in and of itself will bring around a lot of changes for individuals, and also this. So can you go over some of the overviews of changes to temporary work permits in the UK?
Sure. The work permit scheme in the UK is mainly the Tier 2 General and Tier 2 ICT visas. General is new recruits, and ICT is for moving staff from existing organizations overseas. This has been mainly for non-EU nationals up till now, but post-Brexit, the government has announced that anybody from the EU will require Tier 2 visas as well. And that's when having a sponsor license is all the more important right now, given the impending Brexit happening soon. And from 1st of Jan 2020, the new PBS system is being launched, which brings about a lot of changes going forward. And as I said earlier, one of the changes is that every company must have a sponsor license if they want to recruit EU workers from the EU. And because there's so many sponsor licensing being filed as we speak right now, the Home Office is accepting electronic and uncertified documents, although they reserve the right to call for original documents if they have to. And as Mark said earlier, the UK has taken a similar stand, and they're accepting digital signatures for submission sheets. So that's happening here as well. And again, I'd love to see if that continues and if that trend remains for the future, because it just makes life easier for everyone. That's for sponsor licenses. Then coming on to Tier 2 extension applications, they are still allowed, you're still allowed to file for leave to remain or change of employer applications. Employees may start work if the visa application hasn't been decided, as long as the COS has been assigned, the employee has submitted the leave to remain application before their leave expired, and as long as the role which is being used is as per the previous COS. So nothing has stopped. Things are still moving on as they should, but in a slightly different way.